The Supreme Court yesterday ruled that selected courts across the country are to work on weekends, public holidays, and during industrial action or strikes to deal with matters that affect personal liberties.
Yes.
It continued that the power to determine incarceration or grant bail to suspects rests with the courts. And therefore, persons arrested on suspicions, regardless of the jurisdiction and time, must be arraigned within 48 hours. Private legal practitioner Martin Bebu sued the auditor, the Attorney General in 2016 and asked that the court to hold that on a true and proper interpretation, and subsequently we're seeing what the current ruling is. And we do know that there's talk of constant abuse of this, subsequently by the police, etc. Friday, holiday, you are kept in excess of 48 hours. You're a legal practitioner. What have been your own experiences? And then also, with this ruling, what would be the implications?
I recall in 2011, there was a high-profile matter that I was involved as one of them. There were 3 accused persons, and I was one of the lawyers for 2 of them. And we brought an application for the grant of bail 2 weeks before a certain holiday period. And the matter was initially stated for hearing, but the court was dies non. Dies non means the court didn't sit that day.
You said Desmond?
Dies non.
Dies non.
So the court didn't function that day. So as a result of the absence of the judge, I think they attended the seminar. So then we applied for a new date, and the court registrar fixed the new date on a certain Thursday. I think the next day was a Friday, which was a certain holiday. I've forgotten, but I recall clearly. So the application was heard on its merits. We had opposition from the Attorney General's department. We opposed the application, but the court granted the application. Then Cocoa Affairs, it was one of the high courts located in the then Cocoa Affairs premises. Now, the bail conditions were such that we had met them fully by 2 p.m. the Thursday. The registrar had satisfied the conditions. You know, a lot of people also think that the bail conditions are set by the courts. It has to be ascertained by. It's the registrar that would eventually agree that you met the conditions. So, as soon as our clients were released, they were rearrested within the premises by the police. And I know my work, so I quickly, facilitated the drawing up of the court order. So by 4 p.m., my court order, I was lucky the judge didn't leave his chambers soon after court. So I got the order signed by the judge and the registrar. So we had copies. So we followed the police, we followed them to the BNI premises, and we flashed the court order and the fact that we have met the bail conditions. The BNI director then, I think the one in charge at the time, he told us, well, that is the court, this is the BNI. They do things according to what they think must be done. So unfortunately, they cannot release the accused persons because they've rearrested them on new charges. Then I applied for contempt the following week. During the contempt hearing, there are no basis to rearrest the accused persons. In fact, within the court premises. Why? Because the judge was of the opinion that within Act 30, which is the Criminal Procedure Act, permits you to amend your charge sheet if you find a basis to start new charges, to vary them, to even withdraw old ones and substitute. But you don't use your powers to supplant those of the court. So they had acted in a contumacious manner, or in a manner that was contumacious of the powers of the court. And by way of conviction, he cautioned them. So the point is this, that yes, these are very beautiful decisions, because you see, Martin and I I've known him, he's my senior, but we've done a lot of criminal work, and it's because of the frustrations. Because the provision is very clear, Article 14.3, it's very clear, 48 hours should be 48 hours. Yeah. But the police will want to say that 48 hours is exclusive of holidays and weekends. So he was forced to go and have this determined, you know. But recently, even before I'm not surprised about this decision, because the CJ about a month ago issued a practice direction in respect of bail and expanded the frontier. I have to bring you a copy. She expanded the frontier of the conditions under which bail should be granted. And she specified, she gave the layers. Very, very comprehensive. And it's always in my file. I have been reading it since I've been trying to master it. You see, so I am not surprised that because of the new practice direction she's giving on bail, she's transported it from administrative, you know, that one is an administrative wing, and brought it into judicial position. And she's going to ensure that all the courts are going to comply. And they actually, she says that within 6 months, they are going to take steps to establish, to appoint, to designate courts that in times of these situations, they will sit. And I also pray that when those time comes, we won't hear that the judge is not available. The judge is on a holiday. Because it is the judge that is the court.
If the judge is on a holiday,
no, what I'm saying is that practically, you may, because these are unanticipated matters. Yeah. These are unanticipated matters. So no matter, so are you so there's a holiday? No, there's a holiday. Yeah. The judge did not anticipate that there will be an issue. No, there will be an issue, okay, which will keep him in the office. Or? No, there will be an issue with prosecutors, which will compel them to bring an application for hearing in respect of 48 hours. So it's a weekend. It's a long weekend. He's traveled to his hometown. Yeah. You understand? Meanwhile, he presides over that particular court that's designated to hear these matters. That's why I'm saying that these are practical matters that we must fine-tune, you know. So it should not only be one court, but it should be several courts, right, you know, to be able to resolve the matters.
And since you have been involved in entrepreneurship, business, etc., sure, and subsequently you're also a representative of your own people. At the end of the day, these are practical issues that you would wish that the law and the position of the law would be taken due cognizance of, and due recognition will be given to that in their implementation. How would you hope that this is implemented to the letter?
Well, I think I have enjoyed the education from my noble colleague, and of course I'm not a lawyer, so I express just the fact that I think this is an improvement.
Yeah, very.
With the law, we all know that 48 hours is 48 hours, but sometimes when you go to the police, right, you're frustrated. There isn't much you can do. And in fact, they will even try to arrest the person on Friday, goes through Saturday, Sunday, in which case you'll be there more than 48 hours. So it is good that your friend, Martin, tested this, and then has the court has given us a determination that enlightens what we need to hold the police to. And I'm sure they're also going to hold themselves to it, because they know that at this point in time,
the difficulties that they do.
We have the man himself online. Mr. Martin Kpebu, good morning to you.
Hi, good morning, Roland.
Yes, we kept you online for a particular reason, just to make sure that you also got, you know, the discussion and the responses, so that
congratulations to him.
Yes,
so that you can contribute appropriately. Your colleague.
Roland, unfortunately, I was this year, so I wasn't particularly following.
Oh, great. Okay, Roxanne Nelson Dafamapo says congratulations to you, sir.
Oh, okay. Oh, hi. Nelson. Yes, sir. All right. Good morning.
But morning, congratulations. This is the second attack on 96-4, because I recall you went to expand you went to attack the 96-4, the category of crimes that bail will be denied, you know, and you got the court to agree with you that bail should be granted in all, irrespective of the nature of the crime. And this is a further expansion of that frontier, and I'm very grateful.
Honorable, it's for all of us.
Yes.
For the country.
Yes.
Now, Mr. Pebu, we do know it's not the first time that you've gone to the court to seek some of these directives for which you've been given, or your reliefs have appropriately been granted, and subsequently the implementation becomes a problem, unless perhaps I haven't been observing quite rightly the post facto effects of some of those rulings.
So that's the point. After implementation, naturally there will always be challenges, but with time, then we improve. So I guess what you mean is that non-bailable offenses, there are some cases in which bail is denied, right?
Yes.
Hello?
Yes.
You know, as I said, the Supreme Court, the non-bailable decision, it said the discretion to grant is in the court of competent jurisdiction. So it's a judge who will look at the, the information before him in the application for bail and decide. But subsequently, based on these challenges you're talking about, the Supreme Court has an occasion to complain. Yes, I remember that the case Google it. Yes, a number of times it's admonished judges in the lower courts and the rest adhere to the judgment, the non-bailable case, because there were cases in which some of the bail applications, the conditions the judges gave were too stringent. Look for a public officer of a certain grade, director. Can you imagine that the person stand the table must be of the rank of the director in the public service and all that. So the Supreme Court is complained, and I want to believe since there's not been a further complaint, then it means the situation has improved. Otherwise, you know how their losses will not sit down if they see injustice going on. And also, we as citizens may be able to further comment on it. We can say a research on it. How many judges are asking that the person who should sign the table must be a public officer of the rank of director? So my point is that the last time that particular practice, the Supreme Court found it to be unbecoming, the Supreme Court complained. And so since then, if there's not been further complaint, I want to assume that it's been abated. Otherwise, as lawyers, on what basis are you further complaining when you don't have evidence? So, and then the other situation. So we are hoping that with time, the decision will percolate, it will go down. We ourselves, as human beings, we are improving day in, day out as we continue reading. At least, so, Roland, as I tell you that since the non-bailable decision, I've done about 3 bail applications in murder. Or so, 2. And they were both granted. So in both cases, just one of them after 6 weeks, the person was granted bail. Then the other man, his was 1 year. At the time I came in, it was about a year or so. They just granted him bail. And I'm aware there was the third one. I didn't do it, but I was supporting from the side. Yes, that one, so I think he was in custody for about 7 months. The court granted bail. So whatever, even though there are challenges, I believe the situation has vastly improved, at least from my experience.
Yeah.
It won't be perfect.
Okay. Well, thanks for the contribution and all the work that you're doing in relation to this. But let me just give the last word to you.
Yes, I think this is good, Roland. I'm sure that if you push this and we bring it to the police and like the rest will do that
especially
to their face,
the police,
to their face, I'm sure they comply.
Yeah, and I'm sure as members they call you sometimes. They say,
it is only when you don't know that most cases, they take you on and sometimes, you are held or restricted or detained beyond hours. So once people are getting to know about this more and more, and
then they can assert their rights.
That's how I see it, and I think
yes. The other thing is the courts could reach decisions like this, but the police in their operations very often
they ignore it.
They ignore it.
There is a
Yes, you know, and that's what is worrying. Until they themselves find themselves, until their shoes on the other leg, then they see how painful.
But then if they ignore it,
are you making
what will you do?
Are you making reference to
no, not even Agojo alone.
Okay.
But a lot of policemen, I've defended a lot of policemen in criminal matters, and they feel the pinch of being detained in police station.
Beyond 48 hours.
Exactly.
My time is up.
So
well, Roxanne Nelson Dapamapo is a legal practitioner, but also member of parliament for South Dai. Was in his constituency during the district level and unit committee elections, and you did a good job. You always do a good job. Also doing a great job for Bantama. Is their representative and also member of member of the finance committee.
Yes, and road and transport as well.
Charlie, you're a big man.
Hey,
that's why the road minister was on the road.
That's doing action.
Daniel Ochema Bwaje is his name, and thank you very much as well.
Problem.
He's also a certified
public accountant.
Public accountant. That's what the Americans call it.
Yes,
CPA. Yes. All right. So let me just apprise
top
CPA. Since we had an argument, we'll move on to the next segment. Since we had an argument about the voter turnout, let me just apprise ourselves of what the turnout has been. You go to electionguide.org. You go to the countries, etc. You go to the Ghana category. So you have 2000. The election turnout was for presidency 61%. We also have 2004 for presidency, 85%. That's 2004.
Yeah. So it was what?
84%.
That's correct.
85%. That's correct. And then you have 2008 for presidency, 72%. This is important information. And then when you have for 2012, 79%.
Okay.
And then you have for 2016, as we had it, 63%.
Yes.
For 68% for presidency.
So you get it. So I was just saying the right.
Yeah. So it's an
it was low.
All right. So that'll be it for now.
68%.
We're taking a break. When we come back, we'll bring a lot.
68.